Good morning, ladies and gentlemen. First of all, I would like to congratulate Chinning Competition for its 10th anniversary. It's the first time I'm here. I must say I enjoy myself tremendously. This was very funny at the beginning, and I have the impression of being back in a family event. Unfortunately, when you speak about quotes, it's difficult to be funny, so I won't be. I will say a few words about our quote. Of course, in a certain sense, it's your court. When you bring cases in competition cases, you come to us. At least that's what I hope. Then I will say something about our internal organization. As you know, we have, changed over the couple of years. So I think there are some important elements which you need to know. And of course, the reason why we do this, why did we have this change, why did we expand the number of judges, why is it good for the competition community? And thirdly, if time so allows, to speak about the future, and there we might engage in a debate. Unfortunately, I'm coming at the beginning of your conference because so many interesting topics which in fact come into my speech, especially the issue on the burden of proof, which comes at the very last and is, of course, at the core of the presentation here. I apologize for this. In fact, I intended to come at the very end of the conference, but in my new job, I discovered that my existence has become passive and that people organize things for me. I didn't expect that at the beginning, but so it is. I will focus in my presentation on Articles 101 and 102. Of course, I'm happy to take any questions on merger control, state aid, and things like that. So let me start with the organization of our court. Perhaps it's good, since we are at an anniversary event, to go back in time. As you know, the General Court was created in the 1980s. In fact, it was set up in 1989, at the request, in particular, of the European industry. At that time, fines were going up. You had the polypropylene fines, and you have each time fines go up. At that time, of course, it went into the tens of millions instead of the tens of billions, which we may expect in future. But at the time, it was felt that there was an increased need for judicial control in two levels. The Court of Justice at that time was too busy. At least that was the perception of the industry. So a new court had to be created. So our origin of the General Court is a competition court. And that will be, say, the theme of my presentation. The idea of the industry was that you should have 2 degrees of judicial protection and, of course, more in-depth control. It was felt at that time in the 1980s, and I'm looking at some elderly people here in the room. I see some of them, and some pretend not to see me. But it's so that at that time, the intensity of review of Court of Justice, no, that was not good enough. You should have a better court, and that was the General Court. And I think in the 90s we were up to expectation. If you see, for example, what happened in the polypropylene cases, issues like access to file, the position of complainants, the obligation to have due diligence, and of course, as the cherry on the cake, the Air Tours Tetra Laval judgments of the 2000s. So I think we did our job as an intense review court. But we became, in a certain sense, victim of our success. With the Treaty of Nice, the General Court no longer is a competition court. Of course, it still deals with competition cases, but we have become a General Court. In fact, we are the General Administrative Court of the European Union. So everything the institutions or the agencies do come under review before us, if, of course, there is an applicant. That has increased the workload considerably in the first decade of this century. And you know the story, issues of reasonable delay, critics in academic literature about the unbearable lightness of judicial review by the General Court. And all this led to criticism and a need for reform. Indeed, it was true that we were having a big backlog. Just on a personal note, when I arrived at the General Court in 2010, I found cases which dated from 2006 and 2005. So it was not a healthy situation. So something needed to be done about it, and that all resulted in a reform regulation of 2015, which had its effect from 2016 onwards. I don't know whether you know, say, the stages. We doubled the amount of judges in 3 steps. First in 2016, then that was April, and then in September 2016, and now the issue is finished in September 2019. We 52 judges, so we still expect 4 colleagues, 2 Slovenians, 1 Slovak, and hopefully, it depends of course on the events later this week, an additional British colleague. So we will be 56 if everything works well, 54 if events turn out differently. Of course, organizing a court of 54, 56 judges is quite a challenge, especially if you have to have converging or consistent case law. So we did some things about that. First, we have, say, changed the way chambers work in our court. As you remember, in the old days, there were decision-making panels of 3 focused on getting things done. Now we have chambers of 5, which meet as a group and discuss all cases. Of course, when a decision-making unit of 3 within those 5 has to decide in camera when they deliberate, of course, that's secret. But as a rule, when cases come in, they discuss them as a group. That favors the exchange of information amongst the colleagues. It favors also the fact that the judges can go to an extended formation where you will have, for example, in competition cases, 5 instead of 3 judges. So we hope by having more, say, judges on the team that you will have, say, a more varied and a more, better way of judicial review. So that's the first thing we did. Chambers of 5 and more extended formations. Secondly, we took some modest steps, I must say that, in terms of specialization. It's a first step, I would say, a small step for humanity, but a huge step for the General Court, because we specialized half of the chambers, or 6 of them, in trademark cases and 4 others in staff cases. That doesn't mean that they only do trademark cases and staff cases, but that basically that it's the base load of those chambers. All other cases are allocated to them on the basis of a rotation system, including, of course, competition cases. So that's the second important change we made in September. And then finally, we thought that it was good that the Vice President and the President should do judicial work. So that on top of their, say, horizontal functions, they should sit in cases. So you will see me also appear in cases before you. Now, what do we hope to achieve by these reforms? What's the impact you could expect, or at least what I hope you can expect from these reforms? First, deadlines go down. And to give you a figure, in 2011, all cases mixed up, it took 34 months for one case to be solved in 2011. We're now down to 17, so that's a considerable increase. And I expect it to go down to 16, 15. That's the trend we see in, say, the reduction of the duration of proceedings. That's the first thing. The second thing is, of course, that competition cases tend to be more important and that they must be dealt with by judgments. And there again, we see a declining line. It was 54 months in 2011 when to deal with a case, which is very, very long. And we're down to 35 months in 2018. And it will go down even further. But we'll come to that because we have a series of issues to clear as a group. And I speak in particular about the length of the decisions and, of course, then the length of our judgments. They're not easy and pleasant to read. We have a collective problem there, how to shorten and speed up proceedings. And, of course, the reason why we do this is to have more in-depth scrutiny. Now, I understand from Alfonso that courts will be abolished, but for the moment we're still there, and the idea is that we do in-depth scrutiny. And that brings me to the second part of my presentation, which concerns the legitimacy of the system under which competition rules are enforced in Europe. We have a crucial role to play in that area. I will not repeat, of course, the whole Menarini, Chalcot stories and so on. But if you have a system of administrative enforcement, it can only be compatible with Article 6 of the Convention and Article 47 of the Charter if the review courts, national or European, do their work. That, of course, means that we have a specific responsibility in Luxembourg for the legitimacy of the European system. To exercise, or say to bear that specific responsibility, we operate under a system which, I must say, was designed in the 1960s. We try to do our best with existing tools, but they're not necessarily perfect. For example, if you take the system set up by Article 263, the defendant in a competition case becomes the applicant. And that's, of course, a bit of a problem. That relates, of course, to burden of proof issues. Article 2 of Regulation 1 clearly puts the burden of proof on the Commission. But when it comes to an appeal before our court, the defendant suddenly becomes the applicant. Then, of course, we are stuck within the limits of judicial control, of legality control. That means that we control the legality of the act at the time it was adopted. Can you produce new evidence? Under the normal rules of, say, judicial review, that is not possible. But we have adapted as a judicial system, both the General Court and the Court of Justice, that system by allowing parties to come up with new evidence which was not presented during the course of the administrative proceedings. But, of course, there are still limits to judicial control. You need a challengeable act. For example, when it comes to inspections, which take place on the field, that's factual conduct. It's very hard for us to control factual conduct. We can only review, say, the legality of the decision ordering the inspection. But the legality of that decision cannot depend from factual conduct which takes place during the inspection. I refer in this particular matter to the Alco Group case, where you see that the conduct, the factual conduct, is an issue which you cannot or can very difficultly control under legality review. So that's legality review. And then, of course, in order to have the system as legitimate as possible to save, in a certain sense, the whole system of administrative enforcement, we also have the system of unlimited jurisdiction, which complements legality review. I must say there that the case law of the court is not always clear. I thought to have understood it when I read the Galp judgment, but when you have, which clearly says factual findings must be established in the context of legality review, and the proportionality of the fine is something you do under unlimited jurisdiction. But then we get a signal like Infineon, which seems to indicate that we must also do factual findings under unlimited jurisdiction. So that's still an area where you may see the case law evolve. But what I see as a trend, something new, is that we take this seriously, this unlimited jurisdiction. If you take previous judgments in the past, we would stop at legality review and we would see no need to exercise unlimited jurisdiction if it didn't lead to additional elements on top of what we had already found in the context of legality review. Now we take it a step further. In recent judgments, we have legality review, and then we have a separate analysis to see whether the fine is correct or not, even if it doesn't change the level of the fine. But we take the intellectual step to have a look at the proportionality of the fine. So that's what we hope to achieve with this reform, to take this further. Now, have we succeeded or not? That's basically for you to judge. It's for the judges to be judged by, say, the people who come to us. Of course, there are always people who are not happy with our judgments. That's normal. If you lose a case, I've been a lawyer myself, then the court is wrong. And that's obvious, but it's always like that. But you should see it more, say, as a systemic system, a systemic view. Do we do a better job today than we did in the past? I think we do. For example, I don't see articles any longer in the academic press about the unbearable lightness of our review, and we engage in the debate, economic debate with the parties. That brings me to my last comments on the future of the system. And I would like to discuss 3 challenges. First, procedural challenges. Second, challenges of substantive law, and then a systemic problem. First, on the procedure. We manage to reduce, say, the length of our proceedings, but there are limits to it. And one of the problems we face, particularly in big cases, are the numbers of intervention requests. Sometimes hundreds, or I exaggerate a bit, but since we're here, Tedding, I understand, allows me to exaggerate. We get many, many intervention requests in some big cases. That's fine. Of course, people have a thing to say, but sometimes I wonder about the added value of all these interventions. And it also creates, especially in highly delicate cases, confidentiality issues, because the intervening party wants to have access to the information. And the main parties are not necessarily prepared to give the information to the intervener. And there we go. We must make then rules on confidentiality. We have to say all the debate you will have, for example, in big merger cases before the Commission, we will have them at the General Court. And that delays things considerably. I think there we need to think about this. What is exactly the way we deal with confidentiality rules? I would suggest, but that's just a suggestion, that this 5-year rule, which comes from the Evonik Degussa case, that we apply that ex officio, unless there is a good reason, which you put forward to tell us, that information which is 5 years old is still, say, confidential. We should know that. But for the rest, I think everything which is older than 5 years should be in the public domain. So that's perhaps a first avenue to solve these confidentiality issues, which have a paralyzing effect on our proceedings. That brings me to the second problem we face, and that's a collective problem. We, as a group, have, say, ended up in a spiral of lengthy submissions. For example, if you take Commission decision in a merger case, it can be 1,000 pages, and it must be challenged in 2 months. Of course, you say that's the fault of the General Court, because you, General Court, in the Airtours and Tetra Laval judgments and other judgments, imposed high burdens on the Commission. And then the Commission naturally reacts by protecting itself, covering all possible arguments, and then we get these big decisions. Big decisions imply lengthy judicial review. Lengthy decisions often imply much confidential information. And then, of course, we must, as a court, the General Court, do our work properly because we have a review court on top of us, which may say, you didn't answer this specific argument. And there we go. Our judgments become longer, the decisions become longer, your submissions become longer, and we get into a spiral. We should ask ourselves, is this something good? Should we stop it somewhere? I just discussed this with Frank Montag just before we started. I don't have the impression that the decisions we took in the 1980s were significantly less good than the decisions which are taken today. Is it possible to reduce it? And sometimes you see, for example, that administrations try to find their way around these lengthy decisions, for example, by proposing interim measures. But do you need interim measures if the final decision is shorter? So there, I think, is an avenue for reflection. And then, of course, there is also, concerning this length, case law, and now I will stick my neck out a bit, which is not always satisfactory. If you have case law on parent liability, that leads to hundreds of pages, but to where does it lead? What are we looking for these parent liability issues? What is exactly, to say, the added value of this case law? So that's what I see as the procedural challenges: intervention, confidentiality, and the length of these submissions and decisions and judgments, which make, say, the procedure longer, and which do not allow us to take judgments in a period of time lower than 24 months. That's the thing I want to say about procedure. Now about substance. That is, of course, an issue we will discuss at the end of the day. It is, say, the question of what are exactly the expectations of the Court of Justice as to the level of review when it comes to economic evidence. It is true that the interaction between economic studies, economic evidence which we get, and other types of evidence is not always clear. It has been discussed at length what is exactly the added value of what is the intrinsic value, for example, of economic studies amongst these other elements which the court lists, for example, in ground 139 of the Intel judgment. How do you balance these things? What's the role of experts, of witnesses? All sorts of questions we have to ask ourselves. So there, I think, is a new area in which our court will probably venture in the coming years. A second challenge in substance of our case law is the fact that I see more and more decisions challenged, or say more and more procedural decisions challenged. For example, requests for information, inspection decisions. That's fine. That's you're right. That's a fundamental right to challenge these decisions. But what I fear is that the case law may become too harsh. In a time where leniency applications go down, the only thing which is left for the authorities is the ability to carry out inspections and to request information. So we have to be careful to allow the authorities to do their job, because otherwise, as a group, we will be without a job, and that's not in our collective interest. So be careful I say that to the community, to the inspectors, but also to the courts, by having a systemic view on the capability of administrations to carry out their job. And then on the substance, I see another issue, which is timing. In Luxembourg, we are 2 hours away, but we are, say, also a few years back on what happens here in Brussels. We get cases which have been decided by the Commission a couple of years ago, and we review them as best as we can. But often, when we take a decision in a particular case which dates back 3 years ago, or when you take the administrative procedure which took place 5 to 10 years ago, we're dealing with the past. And then when we render a judgment, you interpret that as the state of the law and project it on new developments which sometimes we are not aware of. For example, when it comes to collusion by algorithms. And when the court says, rightly so, for example, in ABB recently, you cannot use presumptions when it comes to establishing substantive infringements. How are we going to reconcile these things? For example, you could also say, when it comes to algorithms, if you use an algorithm, you take the risk that this could occur, and if that is, say, by neglect or by intent, doesn't really matter, you took the objective risk. Is then this case law compatible with, say, this objective presumption that if you use algorithms which can lead to collusion, that this would be an infringement? The question I ask myself, what is the impact of our case law today of developments tomorrow? That means that judges have to stay informed. So it's for us important to be in these conferences. And I think as a group we will work, say, on our presence in symposia and to participate and to learn on what is going on so that we are informed about, say, the consequences of our case law. That's what I wanted to say about substance. And then a few final words on the systemic risk I see in future of the role of our court in the system of competition law enforcement. That risk, in my view, is dispersion. The European Commission now is only one of the many players in the European competition network. And if we have Brexit, we also have a British competition agency working perhaps outside that network. So only one player amongst 27 or 28. When national competition authorities take a decision, they are subject to national review courts. National review courts may or may not interact with the Court of Justice under Article 267, so the preliminary reference procedure. So we have a link between, say, national review courts and the Court of Justice. We also have a link between the Court of Justice and civil courts in the member states when it comes, for example, to private damages actions or private litigation in the field of competition law. But we see the avenue of preliminary reference proceedings becoming more and more important, which is fine. But we review the European Commission under Article 263, on legality review. And the system of legality review, as I just described, has its limits. And how do these two systems interact? Article 267 is, in its very essence, abstract. The Court of Justice interprets the law and sometimes reformulates the questions. That's something we can't do as a review court. We are stuck by the pleas, arguments, and grounds which you put forward. We are not very flexible in the way we can deal with the cases which come before us. That's a first difference. The second difference is that, say, when the court takes a judgment under Article 267, it's an interpretation of the law which must be applied to the facts. And the facts are applied by the national courts. So the Court of Justice, I wouldn't say acts freely, but instead it is, in a certain sense, abstract. And these abstract answers do not necessarily fit to the facts. And there you see often a disconnect. For example, in the case law as well, for example, you take the post-Denmark cases and the Intel case, sometimes it is a bit hard to reconcile. And there I see a problem. If this goes on like this, how are we going to apply as a review court these abstract questions which the court develops in its case law to the facts where we have, say, the final responsibility? I see several answers to that question. First, we must interact among courts. There is a network of courts. The Court of Justice has also a system of judicial system where the judges meet. There is an association of competition law judges, so we exchange, so that's very important. And we will do that more in future. But on the long term, not now, but on the long term, I think that it would be important that the preliminary competence reference, so the competence to take judgments in the field of competition law under 267 goes to the General Court, so as to ensure some consistency between 263 and 267. And of course, that's a projection in the future, but since we're speaking at an anniversary event, and since I started to speak about, say, the creation of the court in 1989, one may perhaps expect that in 2029 we may have that competence. I thank you very much.